Welcome to the Scourgy Law Lunch Break. This is your time of the day to learn a little bit about the law while you enjoy your lunch. Special Counsel Robert Mueller has finally released his report on the investigation into Russian interference in the 2016 presidential election. Mueller's conclusion about allegations that President Trump or his campaign associates colluded with the Russian government is not a surprise. No collusion. I've been arguing that in my columns and on my radio show and on the Scourgy Law Lunch Break videos for nearly 2 years now. Trump is vindicated, and the 2-year-long faux scandal, which nearly split the nation in two, is over, right? Wrong. Mueller, who was a close friend of former FBI Director James Comey, who soon after being fired by the president called for patriotic Americans to stand up to Trump and vote for the Democrats, still found a way to harm the president. Mueller punted on the issue of whether Trump committed the crime of obstruction of justice. Mueller investigated whether the president tried to obstruct justice earlier in the collusion investigation, yet he was unable to reach a conclusion. How is that possible? After sending 2,800 subpoenas, executing nearly 500 search warrants, and interviewing approximately 500 witnesses, Mueller decided, according to Attorney General William Barr, that he could not draw a conclusion one way or the other as to whether the examined conduct constituted obstruction. My guess is Mueller couldn't draw a conclusion because he was attempting to expand the offense of obstruction of justice beyond its statutory limits so that he could at least accuse Trump of committing some crime and score a win for the Stop Trump movement. And Mueller either got cold feet or was stopped by the Attorney General. We will likely learn more about this when Democrats in Congress question Mueller and Barr during the congressional hearings that are sure to come. Obstruction of justice, by the way, is designed to punish individuals for subverting or thwarting the administration of justice by, for example, suborning perjury, destroying or concealing evidence, or by inducing witnesses to give false testimony, as former President Clinton was accused of. Trump, of course, did none of these things. So Mueller, according to Attorney General Bill Barr's prescient legal memo of June 8, 2018, had been toying with the idea of expanding existing obstruction law to include the president's lawful actions based upon his alleged corrupt state of mind or motive. Under this novel and dubious legal theory, Mueller was apparently considering whether he could charge the president for his lawful interactions with former FBI Director Comey about his investigation of Trump's then National Security Advisor, Michael Flynn. Remember that Comey wrote in one of his memoranda that Trump said to him, "I hope you can see your way clear to letting this go, to letting Flynn go." The media reported that alleged statement as proof that Trump was obstructing justice by trying to shut down the Flynn investigation. Newsflash, presidents have the full power under the U.S. Constitution to start and stop an investigation into alleged violations of U.S. law, as well as handle every action in between. Article 2, Section 3 of the Constitution requires the president to take care that the laws be faithfully executed. The president's power to enforce federal law is plenary. The Constitution places no limits on it. The president may delegate his power to lesser officials, including the FBI director, the attorney general, and even a special counsel, but the power remains the president's, and those officials remain subordinate to him. As the chief magistrate of the executive branch, the president had every right to encourage and even order the FBI director to let Flynn go. That's within the president's prosecutorial discretion, which is absolute and non-reviewable by the courts. Trump could have pulled Comey aside and said, "Hey, Jim, you're investigating my national security advisor for having a lawful telephone call with the Russian ambassador. Leave him alone. And if you don't, you're fired. In America, Jim, we don't investigate innocent men for non-crimes." That's what the president could have said. Yet Mueller, like Comey, seemed to be headed down the same wrong path. Thankfully, Attorney General Barr apparently put Mueller in his place. Mueller did manage to get in a parting shot against Trump and for the Stop Trump movement. He wrote, "While this report does not conclude that the president committed a crime, it also does not exonerate him. That's a false statement and a stunning dereliction of Mueller's duty. His job was to determine whether crimes occurred or not leave it to Democrats in Congress to decide." An analysis of the actual statutory crimes of obstruction of justice, not the ones apparently floating around in Mueller's head, compared to the facts of this case, leads to the inescapable conclusion that the president is innocent of the corruption allegation as well. That will be the conclusion that impartial Americans will reach once Mueller's report is published. Mueller and Comey, however, because they could not bring themselves to declare Trump an innocent man, have shamed themselves in their high offices in their relentless effort to stop Trump. Well, that's about all the time we have today for the Scaringi Law Lunch Break. I hope you learned a little bit about obstruction of justice law. If you have any questions or would like to talk to any of our criminal defense attorneys, do not hesitate to give us a call or check us out on the website, scaringilaw.com. Well, thanks for listening and enjoy your lunch.